Major breaking news, the bump stock ban has been struck down as violating the authority of the ATF under regulatory law and beyond. The Sixth Circuit Court of Appeals has so declared just now. Stay tuned, we're going to break it down. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American governor, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the four boxes of American liberty. Okay, folks, huge breaking news. The Sixth Circuit Court of Appeals has just declared that the ATF's attempt to define that piece of plastic known as a bump stock as a machine gun is illegal and may not be enforced. A three-judge panel all ruled against the ATF, saying that there is no way the ATF has the authority to define this piece of plastic known as a bump stock as a machine gun. Now, what's interesting is that this three-judge majority had slightly different views. Two of the judges, Judge Gilman, who actually was appointed to the bench by none other than ready William Jefferson and Clinton, and Judge McKeague, who was appointed to the bench by George W. Bush, held that the statute that defined machine gun was ambiguous, but because the statute deals with criminal law, meaning if you violate it, you go to prison, the rule of Chevron, which we've talked about before, does not apply. Instead, the rule of lenity, which says that when you're dealing with a criminal statute, any ambiguity in it whatsoever is to be interpreted against the government, against the ATF, against the Department of Justice, and in favor of the American citizen. So in this case, two of the judges, Judge Gilman and Judge McKeague, said that the machine gun-related statute as applied to the bump stock ban was ambiguous, and because it dealt with a criminal statute, they applied the rule of lenity, which says that when in doubt, the citizen wins. And then they went on to say specifically that indeed, this statute's clearly ambiguous, and because it's ambiguous, the citizen wins, because all, like in baseball, the tie goes to the runner. Here, the tie goes to the citizen. Specifically, this is what the judges said. And the concurrence, by the way, by Judge Bush, who's a Trump appointee, is even better. But we'll get to him in a moment. So the two of the three judges, they all ruled, by the way, all three judges said the ATF was acting illegally. All three judges agreed. They had slightly different grounds, and we're going to break down how they're different. But it's all good news, all great news, in fact. So the two judges, Judge McKeague and Judge Gilman, wrote, quote, "A significant number of reasonable jurists have reached diametrically opposed conclusions as to whether the definition of a machine gun includes a bump stock. The viability of competing interpretations is exemplified not only by the myriad and conflicting judicial opinions on this issue, but also by the ATF's, let's get this is funny, and also by the ATF's own flip-flop in its position." And the two judges went on to say, quote, "Because the statute is subject to more than one reasonable interpretation, it is ambiguous." Did you just see what I read? They literally made fun of the ATF by saying, by virtue of the, quote, ATF's own flip-flop in its position, and because the statute is subject to more than one reasonable interpretation, it is ambiguous. That is like federal court referring to the ATF as flip-floppers. I feel like I should get flip-flops out and start clapping them, but I'm not going to do that right now. The court goes on to say, as they attack the ATF and point out that the ATF is clearly wrong in this bump stock ban, it goes on to say, quote, "When interpretive principles fail to establish that the government's position is unambiguously correct, we apply the rule of lenity, and resolve the ambiguity in the criminal defendant's favor, or in the citizen's favor. It is not enough to conclude that a criminal statute should cover a particular act." Here's the key language. Quote me on this. Ready? Here's the judge. Ready? Quote, "The statute must clearly and unambiguously cover the act." Now, I think that that language could maybe be applied to some other fights the ATF is in, maybe the pistol brace argument, some of these others. We can talk about that in other videos. Today, I just want to focus on this major victory in bump stock. But yes, this is a precedent that can be used by other judges. And I should note that the Sixth Circuit Court of Appeals is considered a very reputable, serious court. Not all courts of appeals have that same reputation among serious Supreme Court scholars and serious Supreme Court litigators and members of the Supreme Court. We don't need to break down the good and the bad ones now. We can do that in a separate video. But I will tell you that the Sixth Circuit Court of Appeals is viewed as a reputable court, one whose opinion will be taken seriously by members of the Supreme Court. And this decision is quite articulate. And I could see this kind of a decision being cut and pasted by the U.S. Supreme Court at some point. And I do think that this decision dramatically increases the odds that the United States Supreme Court is going to take a bump stock case, which I predicted a year ago. I know last summer there's a couple bump stock cases that were up for certiorari. They were denied cert. A lot of YouTubers were upset about this, and I told everyone, do not be upset. It's all going to work out. You watch. Just give it a little bit more time, and lo and behold, as you can see, the wheels of justice are grinding a little bit slowly because it's the way the system works, unfortunately. But the reality is, you wait. These kinds of decisions are getting noticed by the United States Supreme Court in D.C., and you watch what's going to happen in the next 12 months. So don't get depressed about stuff. You listen to me, and I'll tell you what to get depressed about if there's a need to get depressed. But on bump stocks, don't get depressed. I think we're going in the right direction. Okay, now, I told you there was a 3-judge panel here that all ruled in our favor against the ATF, which is now referred to as the ATF's own flip-flop, flip-flop, flip-flop. The third opinion, which in some ways was the strongest opinion, was by a Donald Trump appointee to the federal bench. That's Judge Bush. And he reasoned that when he read the machine gun definition and the criminal statutes that go along with it, including the NFA, he says that the statute was not ambiguous. He thought it was unambiguous in favor of the citizen. Here is what Judge Bush wrote. It's powerful language, and I can see the Supreme Court picking up this language. Here is what he writes, quote, by the way, he indicates he's okay with the majority opinion. He's not against it at all. He's okay with it, but he wants to concur and point out another independent reason why this bump stock debacle by the ATF was just silly. Flip-flop is too kind of a phrase, by the way, but this is a G-rated channel, so we won't go there. Now, this is what Judge Bush said, knocking out the bump stock ban in the Sixth Circuit Court of Appeals just today, just an hour or two ago. Quote, I would go further. The best reading of the statute is that Congress never gave the ATF the power to expand the law banning machine guns through the legislative shortcut of the ATF's rule at issue in this appeal. Simply put, under the statute, as it currently reads, the addition of a bump stock to a rifle clearly does not make it a machine gun. Did you hear what I just said, folks? Tell me if this rings a bell with, pistol braces? Quote, simply put, under the statute as it currently reads, the addition of a bump stock to a rifle clearly does not make it a machine gun. Though my reasoning differs somewhat from the majority opinion, all judges on this panel agree on this point. It is up to Congress, not the ATF, to change the law if bump stocks are to be made illegal, period, close quote. Powerful language from Judge Bush, and this is the fundamental point. If Congress wants to make something illegal, if they want to make pistol braces illegal, set aside whether or not they can under the Second Amendment. We're not even going to get into that. But if they want to do these sort of crazy things, they need to act and say so clearly and unambiguously and have that legislative fight. But they won't because they can't get those kinds of silly laws through. And even if they could get it through, you'd have Second Amendment challenges. So to summarize, a huge victory today in the Sixth Circuit Court of Appeals. 3 judges basically refer to the ATF as flip-floppers, 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 and effectively, in very civil, polite legalese, made fun of the ATF's position and said it was untenable in all sorts of different ways. A very powerful opinion. I'll put a link to it down below. But the good news is I think we are now a very, very quick whistle stop away from a Supreme Court decision on the bump stock case. This is a big deal because when the Supreme Court speaks to bump stocks, it's going to be talking about the ATF specifically and all their recent authority in recent cases where they've narrowed the scope of administrative law, which they did in things like the West Virginia case involving the EPA, will all come to bear. The full weight of those precedents will all come down on the head of the ATF as I see it. And that will be very exciting to see. And I suspect this is the kind of thing we're going to see in the next 12 to 14 months, but only time will tell. And as my friend says, the history of the future has yet to be written. So let's see what happens. But again, hope you learned something here today. If you haven't subscribed, please do so. And we'll see you again here at the Four Foxes Diner.
Orders up. Table 2A.